Hello, my name is Sandeep M. Hegde. I am a master's candidate at Munich Intellectual Property Law Center, Munich, Germany, and I am one of the co-authors along with Dr. Kalyan Kankanala for the module Trademarks in Cyberspace. That is today's topic for our discussion. If you have read already the module, you will know that this is an advanced topic in the trademark law, and you are required to know the basics and the fundamentals of trademark law in order to appreciate the nuances of the trademarks in cyberspace. To begin with, I am going to briefly explain to you the course and its structure and what we are going to essentially discuss for the next half an hour. To begin with, I am going to deal with some of the fundamentals of trademark law that is necessary for the current topic under discussion, and followed by some of the chosen issues of trademarks in cyberspace, being trademark issues involving meta tags or trademark issues involving keywords advertising or banner advertising, and trademark issues surrounding domain names. The fundamentals of trademark law that we are going to discuss now are only those that are essential for the discussion with respect to trademarks in cyberspace. As I have already told you, at the cost of repetition, I am going to tell you now again that it is very essential for you to know the fundamentals of trademark law in order to better appreciate the nuances of this topic. With that caveat in mind, let us now briefly discuss some of the important points. A trademark, as you already know, is a word, a sign or a symbol which can be graphically represented and which is used in the course of trade to distinguish the goods or services of one person from that of another. Now, if you have heard me closely, you will notice two important things. One being a trademark has to be capable of graphical representation, and second being that it has to be capable of distinguishing the goods and services of one person from that of another. Now, apart from this, trademark also has some very important functions that are recognized by the courts. These essential functions of trademarks become very important for our discussion today. Hence, we are going to discuss those functions that are recognized by the courts. The first, as we have discussed, is the origin function. Origin function is nothing but the capability or the capacity of a trademark to distinguish the goods and services of one person from that of another. If I were to rephrase what I just said, the origin function simply means that a trademark identifies the origin of a specific good or services in the market. Now, distinctiveness is the key to any trademark. The distinctiveness of a trademark is very essential for its performance of the origin function. The second important function of a trademark, which is recognized by the courts around the world, is the quality function. A trademark is a very good indicator of the quality of a particular good or a service. A trademark is a hallmark of the unchanged quality of a particular good or service. Now, when I go to a market, for example, if I can identify a particular goods with its trademark, and I know that a good which bears that trademark is really good, then next time when I go to the market, I do not have to negotiate with the seller about the quality of the goods. I can simply pick up the goods that bears a particular trademark. To take a specific example, if I like Colgate as a toothpaste and if I like the quality of it, next time when I go to the market, I can easily pick up a Colgate toothpaste. Rest assured that the Colgate toothpaste that I bought the second time would have the same quality as that of the one that I bought the first time. This is called the quality function of a trademark. Third essential function of a trademark is that of communication and investment. A trademark, as most of us you may be aware, is a good communicator of the goodwill that the proprietor of the trademark bears. All the goodwill that comes to be associated with a proprietor is actually associated with the trademark, because the trademark is his real identity in the market. Similarly, all the investment that a proprietor makes with respect to a trademark, let us say for promotion of the trademark or for advertising a trademark, all the investment is essentially represented by a trademark itself. The next important function recognized by the courts, or rather the justification for trademark system recognized by the courts mostly in the US, is the search cost theory. Courts in the US believe that trademarks reduce the cost of a consumer in searching for a desirable product substantially, and that reduction in the search cost amounts to consumer welfare. So, this is a consumer welfare angle that the US has brought in to justify the trademark system. With this in the background, now we will move to trademark infringement. Now, all of us know that in order to prove trademark infringement, we need to have a multifactorial test that needs to be satisfied. The first one being identity or similarity of the marks in question, the second being identity or similarity of the goods or services with respect to which the marks are used, third one being the use of the marks has to be in the course of trade, which is being for sale or for advertising of goods or services. The fourth essential factor is there has to be a confusion or likelihood of confusion that is caused by the use of the subsequent mark among the consumers, and the user of the subsequent mark should not have any available defense to save him from a strong case of trademark infringement. Let us now discuss each of these factors of trademark infringement in greater detail. The first and the second important factors for trademark infringement being identity or similarity of trademarks in question and identity or similarity of goods and services with respect to which the trademarks are used are of very high importance. Now, identity or similarity of goods and services and the marks, as we may shortly call it, occurs in three different variations. The first variation is use of identical marks in relation to identical or similar goods and services. This is called a classic case of double identity. In such cases, normally the subsequent user of a trademark is bound to lose a case against him filed for trademark infringement by the previous user. The second variation of the identity or similarity of goods and services and the marks in question is a case where the goods and services with respect to which the marks are used are similar or identical, but the marks by themselves are not identical, but are only similar. For example, a person uses the word Colmate for his toothpastes, whereas the word Colgate is already being used as a trademark with respect to toothpastes. Here the goods are identical. Both users are using their marks with respect to toothpastes. However, the first user's trademark is Colgate, whereas the second user's trademark is Colgate. How would one assess such situations then? In such situations, it is the duty of the person claiming the infringement, in this case it is the proprietor of Colgate, to prove that the second word, which is similar to the first one, is deceptively similar, That means, it is capable of causing confusion in the minds of a potential buyer. The third variation in which such cases exist are the marks are similar or identical. However, the goods and services with respect to which the marks are used are dissimilar or completely unconnected. In such cases, it is very difficult to prove a strong case for trademark infringement. In most of such scenarios, it is very likely that the court may hold that there is no trademark infringement. However, the only recognized exception to this rule is that of well known trademarks, which we are going to discuss in greater detail in later point in time. The third requirement for a successful trademark infringement action is use in course of trade. In the European Union and in India, we normally call it the use in course of trade, whereas in the US it is called use in commerce. The terminologies may be different, but then the meaning that they convey are similar. It is very essential for a person claiming trademark infringement to prove that the defendant was or is using the mark which is similar to that of the plaintiff. What in law then the term in the course of trade mean? The term in the course of trade has very huge connotation, which covers anything that has a commercial significance to it. The use further has to be in connection with a sale or advertisement of a particular goods or services. Furthermore, the use of a trademark has to cause confusion in the minds of the public or should be likely to cause confusion in the minds of the public. This requirement is broadly known as likelihood of confusion. Likelihood of confusion may occur in three different levels. The first one being initial interest confusion. Initial interest confusion occurs when at the time of advertising the usage of a similar or identical trademark is made and a potential buyer is confused with respect to the origin of goods. Let us say that I intend to buy a new car and there is a specific model that I want to buy, which is being Maruti Ritz. For example, there is a new manufacturer of cars who manufactures a new car with the name Kids, and he extensively advertises it. Now, I may develop a confusion in my mind with respect to the origin of the car, and I may buy Kids believing that it is Ritz. So, this is called an initial interest confusion, where the confusion is at the level of the interest of the potential consumer. The second one is the point of sale confusion. Point of sale confusion occurs when a consumer is confused with respect to the origin of the goods at the point of sale. For example, when two competing products bearing a similar trademark is placed side by side in a store or in a supermarket, the consumer is likely to be confused at the point of sale and likely to pick up a product believing that he was picking up a different product. This is called a point of sale confusion. And the third one is the post sale confusion. Post sale confusion occurs when a person knowingly buys a third party product. However, the potential consumers in the general public are led to believe that the product purchased by the consumer belonged to a different manufacturer or a different proprietor. In most cases that occurs on cyberspace that relate to trademarks, initial interest confusion forms the major part of the likelihood of confusion on cyberspace. There are certain defenses that are available against trademark infringement. I would really mention them rather than explain them because of the brevity. The first defense being nominative fair use, which simply means that if you are using a third party trademark to indicate that the goods and services of the third party himself, then there is it amounts to nominative fair use and you are exempted from any trademark infringement claims. Furthermore, the second defense that is available to you would be the first sale exhaustion, which simply means that once a sale is made with respect to a particular piece of article which bears a specific trademark, which is lawfully done, the person who purchases such goods with the trademark has a legal right to resell it without having to ask the proprietor of the original trademark. The right of distribution with specific to that particular article that is sold is exhausted, and that right is transferred to the person who buys it. Another form of trademark infringement that is most common or most typical of well known marks are trademark infringement by dilution, tarnishment and unfair free riding. Before we delve into the details of trademark infringement by dilution, tarnishment or unfair free riding, it is very important for us to know what are well known marks. Well known marks are those trademarks for which the consumer association with its proprietor is so very high that in a future point in time, if a person uses, if a third person uses, if at a future point in time a third party uses the same mark with respect to a completely different set of goods and services from that of the original proprietor, the consumers are likely to be led to believe that the goods and services of third party originated from the original proprietor. Now, the well known marks are clearly defined under section 2 of the Indian Trademarks Act. Well known marks are all called famous marks in the United States of America, and it is called marks with reputation in the European Union. Irrespective of the terminology, the typical nature of well known marks with respect to trademark law is that they enjoy a high amount of exceptional protection under the trademark law. Most trademarks, normal trademarks, are protected only with respect to the goods and services with respect to which they are registered or used. However, well known marks are protected with respect to all set of goods and services irrespective of their use or their registration. Now, if any third party uses a well known mark in relation to goods other than the original goods, then it amounts to infringement by dilution. Whereas, if the same third party uses the trademark in a way so as to cause damage to the original trademark, then that would amount to infringement by tarnishment. And finally, if the third party uses the goods and services, the trademark with respect to any goods or services with an intention to free ride on the goodwill of the original proprietor, then it would be called trademark infringement by unfair free riding, or as the French call it, parasitism. Now, with these basic pointers with respect to fundamentals of trademarks in mind, now we will delve into specific issues of trademarks in cyberspace. Now, the only reason why we picked and chose certain important aspects of fundamentals of trademarks is that these aspects are going to come into play in our assessment of trademark infringement over cyberspace. Now, we have chosen only a few important trademark issues on cyberspace among a host of issues that one may encounter on a daily basis. Now, they are the first trademark issues surrounding meta tags, second trademark issues surrounding keyword advertisement and banner ads, and third being trademark issues surrounding domain names. Let us begin with meta tags. Before we start with the trademark issues specific to meta tags, it is very important for us to understand what are meta tags. Now, internet has a plethora of information which is stored in millions of websites. Each website has, or each website comprises of a number of web pages. Each web page has two sides to it. One is the front end, which we as users see and read. Other is the back end, which only the machines or the computers see and read. Now, this back end of every web page is very important, because it hosts a lot of information in a machine readable language like HTML in order to cater to the requests of a user. We all know the importance of search engines like Google. It is probably very difficult to imagine a life on cyberspace without knowing how to use search engines. Now, search engines search for information based on the search query entered by a user and draws up search results for the user based on the search queries. Here is where the meta tags come into play. A web page may contain numerous information. Now, the owner of the web page may want to highlight certain information, and he encapsulates the information on the web page into certain keywords that best represents the web page. Now, these keywords are inserted in the back end of the software, the web page, which are called meta tags. Now, these keywords are important from the point of view of the search engines. Now, whenever a user enters a word as his search query, the search engine looks into the meta tags of all the. Whenever a user enters a keyword as a search query in a search engine, the search engine looks through the meta tags of all the web pages that it can find and pulls out the web pages with similar meta tags or relevant meta tags in the search results. Therefore, meta tags are very important components of any web page. Now, how about use of third party trademarks as meta tags? What if a competitor uses a third party trademarks as his meta tags on his website? Whenever a person enters a search query with that particular trademark, he is most likely to be directed by the search engine to the competitor's web page. Now, would such use by third party of the trademarks as meta tags amount to infringement or passing off, or whether meta tags amount to use in commerce or use in course of trade, or whether there is confusion or likelihood of confusion caused because of the use of trademarks as meta tags by the competitors. Now, these are some of the questions that are answered Now, these are some of the questions that are waiting to be answered or are under answered by the courts in many jurisdictions. Let us now first look at USA, because the initial cases with respect to meta tags emerged in USA. One of the first cases that dealt with the question as to whether use of trademarks as meta tags amounts to trademark infringement or not involved a patent law firm called Oppendahl and Larson. Now, Oppendahl and Larson is a registered trademark, and it was quite famous in the US at that point in time. Now, the defendant Advanced Concepts used the words Oppendahl and Larson as his meta tag, and he also was offering similar set of good services. Now, Oppendahl and Larson obviously brought in a trademark infringement lawsuit, and here the court held that use of meta tags use of trademarks as meta tags amounted to use in course of trade. Another interesting case which involves a very famous magazine called Playboy International. Now, as you already know, Playboy and Playmate are registered trademarks of Playboy Inc. Now, the defendant Calvin Designer Label was into the business of sexually explicit. Now, the defendant Calvin Designer Label ran certain websites which contained sexually explicit materials, and he used the meta tags Playboy and Playmate on his web pages. Now, Playboy sued Calvin Designer Label, and the court held that use of Playboy's registered trademarks as meta tags amounted to trademark infringement. However, not all trademark uses as meta tags amounts to trademark infringement. Our next case is our next case substantiates this point. In Playboy versus Welles, the defendant was a model who posed for photographs to be featured in the Playboy magazine, and on her personal website she used Playboy as one of her meta tags. Now, Playboy sued the defendant for this act for trademark infringement, and the court held that the defendant had valid reasons to use Playboy as her meta tag on her personal website, because she was one of the models for Playboy magazine. Now, this argument was accepted by the court, and court held that there was no trademark infringement. Now, I have also included another very famous case called NAM versus Axiom, where meta tagging is held to be a form of advertising. Now, I will leave it to your discretion to read and appreciate how the court has come to the conclusion that meta tagging amounts to a form of advertising. Now, in India, cases with respect to meta tagging has been very few. Now, one of the very famous cases involving trademarks as meta tags is Qasim Info versus Google and others, which is better known as Bharat Matrimony case. Now, we are going to discuss this case in very great detail in our next segment. However, here for the purpose of our discussion on meta tagging, it suffices to say that court has discussed most of the foreign cases in very great detail with respect to meta tagging in Bharat Matrimony decision, and it is worthy of an interesting read and it is recommended that the reader goes through the original judgment by the Madras High Court on Bharat Matrimony case. Coming to our next segment on trademarks in cyberspace, keyword advertising and banner ads. Let us now first discuss what is keyword advertising. Now, most of you may know about Google's AdWords project. Now, AdWords is one of the business models of Google, where Google sells many keywords as AdWords to businesses. Businesses can simply purchase or bid for those AdWords, and whenever a person as a common user places certain search queries on Google search engine involving such AdWords, in the results Google places ads of the purchaser of the AdWords as banner ads, or before the beginning of at the beginning of the search results the ads are placed. Now, if you go through the reading materials, we have provided an illustration where a search for Ray-Ban yields many advertisements by third party vendors before the actual search result begins. Now, the obvious questions involved here are whether use of third party trademarks as AdWords by competitors amounts to infringement, or better yet, whether Google's use of third party trademarks to sell them as AdWords or keywords amounts to an act of infringement, and whether either Google's use or the use of the competitors amounts to use in the course of trade. And the final question here, which is very interesting of course, is whether is there a likelihood of confusion at all. Now, there have been a string of cases answering these questions. We are going to discuss a few of them in each of the jurisdictions that we have chosen. Beginning with USA, the first case that discussed the above questions was RescueCom versus Google. Here, the court of first instance that decided on the case said that there was no infringement at all by Google, and there was no use that was actionable when Google actually sold a third party trademark, being RescueCom's here, to competitors as keywords. Now, this case was taken on appeal to the Court of Appeals, where Court of Appeals reversed the decision of the court of first instance and said that Google had recommended these AdWords to the competitors of RescueCom, and that act of recommendation itself amounts to use in commerce. Now, bear in mind that the Court of Appeals does not rule on infringement. It simply rules on whether Google's act of recommending the RescueCom's trademarks to its competitors amounts to use in commerce or not. Coming to the European Union, in a similar case filed against Google France and Google Inc. in general by Louis Vuitton, one of the very famous brands, lifestyle brands. It was held by the Court of Justice of the European Union that there was no liability at all from the Google's end, because there was no adverse effect on any of the recognized functions of a trademark. Now, before we begin or before we delve into the details of the European Union cases, it is to be borne in mind that in addition to the multifactorial test that one conducts for trademark infringement, another requirement imposed by the Court of Justice of the European Union for a trademark infringement is that the act of using of a third party trademark should have an adverse effect on one of the recognized functions of the trademark that we have discussed earlier. Now, here in this case, the Court of Justice of the European Union clearly said that the use of Louis Vuitton's trademarks by Google for its own internal purposes did not amount to an adverse effect on any of the recognized functions of the trademark. Now, in another case involving Interflora and Marks and Spencers, Now, for those of you who are not aware of these brands, Interflora is a very famous brand which is into flower delivery services in Europe. Marks and Spencers is a very popular consumer brand, and Marks and Spencers wanted to get into this new business of flower delivery. Now, Marks and Spencers bought some of these adverts now Marks and Spencers bought some of these adverts relating to trademarks of Interflora and used it to provide advertisements relating to its flower delivery services, and Interflora brought an action against Marks and Spencers. Here the Court of Justice of the European Union clearly said that if a competitor buys and uses adverts as keywords to place its online advertisements, then such an act would amount to trademark infringement. However, the Court of Justice of the European Union did say that Google would not be liable for contributory infringement, since its acts did not amount to any adverse effect on any of the recognized functions of a trademark. Now, coming to India, the biggest case when it comes to trademarks in cyberspace is Cosim Info versus Google, which is better known as Bharat Matrimonial case. Here the court said, taking a different position than that of US and European courts, taking a different position than that of a European and US courts, the High Court of Madras said that Google's use of the third party trademarks as adverts amounted to use in trade, no doubt. However, there was no act of infringement simply because Google did not use them as whole trademarks, but broke them into different keywords. Now, this is a decision specific to Bharat Matrimony itself. So, the outcome would be different in cases where Google has used whole trademarks as keywords for its advert business. Now, coming to trademark issues surrounding domain names. Now, as we all know, web addresses or domain names are corporate identity of any business in cyberspace. Now, a business can hardly exist online or on the internet without having its own website and without having its own domain name. Therefore, lot of courts have recognized trademark rights in domain names. Now, when we look at a typical domain name which reads something like www.example.com, which is on your screen right now. Now, you will see that this web address is made up of three parts. The first one being a subdomain, which is represented by www dot or any other subdomain for that matter. The second one being the domain name, which is represented in blue on your screen, and the third one being the top level domain, which can be represented by either .com or .info or .co.in, etc. It can be anything. Now, when we say trademark rights in a domain name, we are actually referring to the central portion of any domain name or any web address, which is represented in blue here. Now, one of the major trademark issues that involves a domain name is cyber squatting or domain squatting. Now, domain squatting or cyber squatting simply refers to an act where a person purchases a third party popular trademarks as domain names and simply sits on it without using it. The only intention with which he buys it is to resell it to the trademark owner for a exponentially high price. Now, this act is called cyber squatting or domain squatting. Now, there are multiple remedies available for the act of cyber squatting. The first and the foremost remedy is offered by the central body governing the domain names, which is ICANN, together with World Intellectual Property Organization, that is WIPO. Now, this is called the Uniform Domain Name Dispute Resolution Policy, which is shortly called as UDRP. Now, this is nothing but a simplified arbitration procedure, where the UDRP arbitrator grants you just the transfer of domain names to which you are rightfully the owner of the trademark, and there is no monetary damages given in under UDRP, and this is solely enforced and the jurisdiction is assumed by UDRP on the basis of the agreement that one signs when he registers a domain name. Now, it is completely contractually governed. Now, apart from the UDRP dispute resolution policy, if one wants other damages that are available under the trademark law or common law, one has to approach the regular courts. Now, lot of courts around the world have recognized trademark rights on website names or domain names, and India is not an exception. Now, if you see the reading materials, I have included two cases. The first one being Yahoo Inc. versus Akash Arora, which is one of the first cases involving domain names, trademark infringements on domain names, and Satyam Info versus Sifi.net. In both the cases, the court has granted remedies for either an action for passing off or infringement, citing that a proprietor of a trademark owned trademark rights over its corresponding domain names as well. Now, with that, I am going to conclude this talk here. Now, at the cost of repetition, I am going to tell here again that this is in no way an exhaustive account of all the trademark issues that one comes across in cyberspace. We have only picked and chosen those issues that are most relevant and most discussed upon, and we have provided some reading materials which are highly recommended for those of you who are interested in reading more about trademark issues in cyberspace. I highly recommend that you go through that. Thank you so much. Thanks again.